Get ready. 3 seconds. 2 seconds. Start. The prosecution relies solely on the evidence of the prosecutrix as regards the commission of sexual intercourse on her. She did not inform anybody about any rape committed on her by the accused appellant. Only when her monthly course stopped for 3 months and the sign of pregnancy became apparent, she disclosed it to her mother, and the affair was lost after 3 months of the alleged occurrence. Please stop. In her evidence, she deposed that the accused impregnated her. Please stop. On this point, also, there is no evidence save and except her own uncorroborated testimony. Please stop. The doctor, PW4, examined her after 3 months. Please stop. His evidence is silent about her pregnancy. Please stop. Her statement that she became pregnant does not find corroboration from medical evidence. Please stop. It cannot be said that the prosecution has succeeded in proving that the accused had sexual intercourse with her, as a result of which she became pregnant. Please stop. Even assuming that the accused had sexual intercourse with her, it has not proved that he did so without her consent. Please stop. In cross-examination, she categorically stated that she had been in love with the accused appellant. They exchanged love letters. Please stop. In view of the evidence as discussed above and in the facts and circumstances, the irresistible conclusion is that if the accused had sexual intercourse with her, it was with her consent. Please stop. This has been corroborated by circumstances that she did not tell anybody about the sexual intercourse with the accused appellant till she became pregnant. Please stop. If a full-grown woman consents to the act of sexual intercourse on a promise of marriage and continues to indulge in such activity until she becomes pregnant, it is an act of promiscuity on her part and not an act induced by misconception of fact. In this regard, learned counsel for the appellant has referred to a decision in Jayanti Rani Pandey versus State of West Bengal 1984 CRI LJ 1535, wherein has been stated, the failure to keep the promise at a future uncertain date due to reasons not very clear on the evidence does not always amount to a misconception of fact at the inception of the act itself. Please stop. In order to come within the meaning of misconception of fact, the fact must have an immediate relevance. Please stop. If a full-grown consents to the act of sexual intercourse on a promise of marriage and continues to indulge in such activity until she becomes pregnant, it is an act of promiscuity on her part and not an act induced by misconception of fact. Section 90 IPC cannot be called in aid in such a case to pardon the act of the girl and fasten criminal liability. Please stop. Learned counsel submits that the learned session judge convicted the accused appellant under section 376 IPC on the basis of the defense suggestion put to the prosecutrix, PW2, that the accused had sexual intercourse with her consent, full stop. Learned counsel has strenuously argued that the learned trial court was not justified in taking the aid of such suggestion in course of cross-examination, full stop. In support of his contention, he referred to a decision in Sakaria versus State of MP 1991, CRI LJ 1925, wherein it has been held where in case of a charge of rape under section 376 penal code, the statement of accused contained plain denial and a plea of false implication, subsequent suggestion by the defense lawyer to the prosecutrix about consent on her part would not amount to admission of guilt on behalf of the accused, full stop. A suggestion thrown by the defense counsel to a prosecution witness does not amount to any admission on the part of the accused, full stop. It is a common practice to suggest a witness while he or she is under cross-examination, the case of the defense when such evidence or suggestion is denied, it does not constitute any evidence, full stop. Suggestions put are no evidence at all against the accused, and on the basis of such suggestion, no inference can be drawn against the accused that he admitted the fact suggested in the cross-examination, full stop. The proof of guilty required of the prosecution does not depend on the suggestion thrown to a witness.